On June 26th, the United States Supreme Court ruled in the Windsor case that individuals in same-gender marriages are no longer barred from federal recognition of their marriage. The Supreme Court determined that Section 3 of the Defense of Marriage Act, or DOMA, was unconstitutional. This will mean that in many cases, individuals in legal same-gender marriages will be treated as any other married couples in the United States. What we don't know at this point is what happens to a married couple living in a state where their marriage is not recognized. Currently, 12 states and the District of Columbia license same-gender marriage. But for purposes of federal law, some laws are based on where the marriage was celebrated, and other federal laws are based on where the couple currently resides. So, if a couple is living in a state where their marriage is not recognized, the IRS may not recognize their marriage for federal tax purposes. If plan sponsors are not now providing benefits to spouses in same-gender marriages, they may want to consider doing so. Up until now, there was an impediment to providing that coverage. The value of the coverage provided to a participant's same-gender spouse could not be provided on a tax-qualified basis, just like benefits to domestic partners cannot be provided on a tax-qualified basis. What that meant was the value of the coverage provided to the same-gender spouse was imputed as income to the plan participant, and they would have to pay taxes on that coverage. The employer would have to pay FICA and other payroll taxes on the coverage, and that has now been removed, at least in states where the same-gender marriage is recognized. Certainly, for plan participants living in a state where their marriage is recognized, in a retirement plan, a same-gender spouse needs to be treated as any other spouse, including obtaining spousal consents, eligibility for pre-retirement death benefits, being able to obtain retirement benefits in a joint and survivor form. It also means all other plan provisions referring to spouses must be adhered to, including minimum distribution requirements, as well as honoring qualified domestic relations orders. For plans that are currently covering domestic partners, it's important to remember that domestic partners are not the same as legally married spouses. For example, providing health benefits to a domestic partner is still going to result in imputed income to the plan participant, even if they are living in a state where same-gender marriage is recognized. What plan sponsors may want to do is take some time, communicate with their participants, and see if in fact they are in same-gender marriages. And if they can provide the documentation that they're in a legally recognized marriage, in this case, the imputed income would stop. And you'd know that they were eligible for benefits under a retirement plan. For plans that are only covering domestic partners and haven't considered covering same-gender spouses, they're probably going to want to take a look at that now that same-gender marriages are legally recognized under federal law, at least in the states that recognize those marriages. Certainly, there are some outstanding questions. One significant question is whether the Windsor decision can be applied retroactively. For a health plan, we'll need to take a look at imputed income. Can imputed income be changed going back? For a retirement plan, are there benefits that might be payable? Another question where guidance will be helpful is whether participants can make changes in their Section 125 flexible benefit elections mid-year, or will they have to wait until the next open enrollment period? Our clients are looking at how the Windsor decision applies to their plans. First and foremost, they're looking at where their participants live and whether they live in states where same-gender marriage is recognized. Our clients are communicating with their participants. they're finding out if their participants are in same-gender marriages, which then could entitle them to benefits under the plan. Participants that are in health plans will no longer have imputed income, again, at least in states where the same-gender marriage is recognized, and plan sponsors are determining when that imputed income can stop and whether adjustments can be made retroactively. For retirement plan sponsors, they're looking at recent retirements, at recent benefits paid, and determining if there will be an impact on participants who are in a same-gender marriage. Very importantly, many clients are communicating with their participants, and they're finding that participants are eager to hear from the plan sponsor about the Windsor decision, about this change in the DOMA law, and whether this will have an impact on them and their benefits.